Welcome back to the channel, everybody. Back to the Butterfly Monkey Effect channel. Hopefully you guys are all caught up on my other videos, especially the citizenship videos, since that will be the topic for today. In my other videos, I spoke and read specifically authorities of law on the topic of citizenship. So I used, of course, books on elementary law and American citizenship and so forth. Today it will be case law. Case law showing that goes back before and after the 14th Amendment, showing what the terms actually mean, meaning the term for the United States in the Citizenship Clause of the 14th Amendment. The word person, right, is another one that it can be construed. The word person in the Citizenship Clause only means a natural person, meaning a living, breathing man or woman. It does not include a corporation. And for sure, the existence of U.S. citizenship prior to the 14th Amendment, right? So that's what I hope to be able to show today in this video. For sure, I would like a debate. Why? Because if there is contradictory evidence to what I'm stating and showing here, then I would like to know about it. I don't want to run or hide from it. As a researcher, my goal is to find out specifically what is true or not. So, this case in front of us is called Hooven versus Allison. So the court cases I want to be going through go back to at least 1856 all the way to 1998. Okay? I'm going to start with this one, Hooven versus Allison from 1945, without, of course, reading it all. I'm showing it so you guys can read it, but understand what the case is about, right? So Hooven versus Allison was about importation, specifically food articles from the Philippines. Okay. In this case, they broke down the terminology for what the United States means in the tax clauses, right? The uniformity clauses, right? They bring up the court case from 1901. These are the insular possession cases. There are 4 of them. The most famous of the 4 is Downs versus Bidwell. This one right here. The most informative of the 4 is the Lima versus Bidwell, for your understanding on how they interpreted that term, the United States, specifically for the uniformity clauses, but also in Downs for the 13th and 14th Amendment. Okay? In this court case for Hooven, they point out that the term can mean 3 different things. It's important to understand this. That it could mean 3 different things, and context is the only thing that matters to know which one is being used. Okay? The term United States may be used in any one of the several senses. It may be merely the name of a sovereign occupying a position analogous to the to that of other sovereigns in the family of nations. So that's in relation to Canada, Germany, Mexico, so forth. It may designate the territory over which the sovereignty of the United States extends. That's the federal government here. Why is this over the sovereignty of the United States extends? Because the way this phrase is the powers of the people given to the federal government. That is where our power extends. In the end, this is how it has to be interpreted. Or it may be the collective name of the states which are united by and under the Constitution. Okay? You got to understand automatically that depending on what you're reading, one of these are going to be used. It cannot always be Congress, the federal government, or it's a corporation or something like that. And their footnote for this is all these authorities of law, meaning Harvard Law Reviews, the books, everything. They track down all the court cases, you name it, it's here. Anything that you would be looking for to verify what they're saying on how there's different meanings for that term is right here. Okay? That leads us to, okay, what is the term, how is the term being used in the Citizenship Clause of the 14th Amendment? Okay? I come to this court case. This is Belmonte versus the Immigration and Naturalization Service. Okay, this is a 1998 case. In this court case, it is about a lady who was born in the Philippines during the time when it was a territory. Her argument was that by use of the 14th Amendment, right, she is a United States citizen. She was applying the principle, it's a common law principle that the British used to use and the Romans used to use, that even in territories that are conquered or whatever else, purchased by whatever other means, if you're born out there, you're also a citizen or a subject in terms of the British. It also gave citizenship. This country did not adopt that standard. They adopted only birth on the land, specifically the land who created the contract. Right? The Declaration, the Constitution, and so forth. They restricted that birthright, that common law principle within the borders of each state. It doesn't apply to the territories either. Of course it doesn't. But they also did adopt birth by blood. Okay? But that is a statutory provision. Literally like 1 year after the Constitution was created. It is not made part of the Constitution. The 14th Amendment enshrines the principle of born on the land. And so does the description of the citizen that they describe in Article 4 of the Constitution. Right? Petition for review of a decision of the Board of Immigration Appeals upholding an immigration judge's decision to deny petitioners application for suspension of deportation and order petitioner deported to her native Philippines. The issue on appeal is whether the petitioner's birth in the Philippines, while that country was a United States territory, confers on the United States citizenship, on her United States citizenship under the 14th Amendment. We conclude that it does not. So what did they do here to conclude this? Right? It's all about the context of what the Constitution is. It is for the states, right? For its people, for its representatives, It's not about the territories. Territories weren't even in question outside of within North America, right? Philippines and all those other things were never considered or construed during that time. But in here, they tell you something specific. They give you the whole history of the progression of sovereignty that the Philippines went through, being conquered by Spain, being won over in the war with Spain, with the United States, and so forth. Even the Independence Act that was in the 1930s or whatever, for them to become independent. Like, they go through the whole little history on this. So here's the discussion, right? The principal issue in this petition is the territorial scope of the term "the United States" in the Citizenship Clause of the 14th Amendment. It states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Emphasis added. Petitioner was born in the Philippines in 1934 during its status as a United States territory. Argues she was born in the United States and is therefore a United States citizen. Petitioner's argument is relatively novel, having been addressed previously only in the Ninth Circuit, and this is a good court case too, to understand. No court has addressed whether persons born in the United States territory are born in the United States, within the meaning, and this is the context, which I stress all day long, within the meaning of the 14th Amendment. In a split decision, the Ninth Circuit Court, which is Rabang, held that birth in the Philippines during the territorial period does not constitute birth in the United States under the Citizenship Clause of the 14th Amendment, and thus does not give rise to United States citizenship. We agree, blah, 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 okay? For the purpose of deciding this petition, we address only the territorial scope of the phrase, the United States. We do not consider the distinct issue of whether citizenship is a fundamental right, which is a birthright, protected by the people of your community. That's really what it's supposed to be. There's a couple. There's a few ones that I'm gonna read out of this court case. But like I said, Hooven first, Belmonte to understand why they're calling this the United States means only the several states. Despite the novelty of the petitioner's argument, the Supreme Court in the insular possession cases, which this is Downs versus Bidwell and De Lima, provides authoritative guidance on the territorial scope of the term the United States in the 14th Amendment. So they're saying in 1901, they gave and addressed the scope of the 14th Amendment. The insular cases were a series of Supreme Court decisions that addressed challenges to duties on goods transported from Puerto Rico to the continental United States. Puerto Rico, like the Philippines, had been recently ceded to the United States. The court considered the territorial scope of the term the United States in the Constitution and held that this term, as used in the Uniformity Clause of the Constitution, was territorially limited to the states of the Union. So just solely the Uniformity Clause, right, only construed the states. Okay? All duties, imposts, and excises shall be uniform throughout the United States. Emphasis added. Downs versus Bidwell. Section or page 244. It says, it can nowhere be inferred that the territories were considered a part of the United States. The Constitution was created by the people of the United States as a union of states to be governed solely by representatives of the states. In short, the Constitution deals with states their people, and their representatives. Puerto Rico was merely a territory, appertinent and belonging to the United States, but not part of the United States within the revenue clause of the Constitution. Now, what is this saying? It's telling you that that term does not include territories. And it didn't include the District of Columbia. It just meant the states. The court's conclusion in Downs was derived in part by analyzing the territorial scope of the 13th and 14th Amendment. The 13th Amendment prohibits slavery and involuntary servitude within the United States or any place subject to their jurisdiction. What did they say? Their jurisdiction. That's plural. That means that this term, for sure, just in that context of their, the pluralness of that, this has to mean the states. But how is it that it's under their jurisdiction? It's through their representatives in Congress. The 14th Amendment states that persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The disjunctive or, so the word or, this is how they broke it down instead of the word there, right? The disjunctive or in the 13th Amendment demonstrates that there may be places within the jurisdiction of the United States that are not part of the Union, to which the 13th Amendment would apply, which, of course, even before the 13th Amendment, the Northwest Territories, I believe, or at least the Louisiana ones, territory, they had provision where slavery was not allowed. I hope you guys know that. It was just the states that were left over from holding slavery as a thing. The federal government already had that in place in the future, for the future, with those territories. Citizenship under the 14th Amendment, however, is not extended to persons born in any place subject to the United States jurisdiction, but is limited to persons born or naturalized in the states of the Union. That's Downs, page 251. See also page 263, which we should go to that. In dealing with foreign sovereignty, now this is what we are understanding and construing that what that term means every time we see it. In dealing with foreign sovereignties, the term United States has a broader meaning than when used in the Constitution and includes all territories subject to the jurisdiction of the federal government, wherever located. It can't mean this everywhere. 3 different ways from Hooven and Allison. At least that's the last time they defined it in any way. Congress, under the Act of February 21st, 1871, so this is the Act of 1871, expressly extended the Constitution and federal laws to the District of Columbia. Even without that act, the laws, the courts would have found that the Constitution applies to the District of Columbia in regards to protections, because it's the law of the land, and the law was established, what do they say right here? Stating that the mere cessation of the District of Columbia from portions of Virginia and Maryland did not take the District of Columbia out of the United States or from under the shield of the Constitution. So, like, and this is something what I want to state that's kind of redundant, right? Them doing this, expressly extending the Constitution, maybe not the federal laws, but for sure the Constitution, right, to the District of Columbia. It didn't matter. This to me is a nullity because it doesn't matter if they do it or not. The principle is that it attached to the land prior to giving it to them. So it didn't take it out of the protection of it, its people and whatever else. But it was still a territory. They were still limited in whatever for the territories. Following the decision in the insular cases, the Supreme Court confirmed that the Philippines, during its status as a United States territory, was not part of the United States. See Hooven, which is the first one I told you. As we have seen, the Philippines are not part of the United States in the sense that they are subject to and enjoy the benefits or protection of the Constitution. That's what it's all about. As do the states which are united by and under it. I'm gonna stop right there with this case. My goal here was to point out how it's being defined. Right? There's a 1998 case saying that the 1901 case was stating this. And then they show their rationale on why there's... And since it means three different things, right? It means the federal government, its territories. It means the states by themselves or the empire. This automatically takes out two of them. It can't be the empire because they're not including the territories. And it cannot be the federal government and territories because they're expressly saying that it does not define it as including that. So that means out of the three definitions, there's only one left. The definition is the several states of the Union. So now the criteria for being a U.S. citizen is any and all persons born or naturalized in a state of the Union are citizens of the United States and of the state where they reside. You tell me. Outside of saying, like some people do, that the several states of the Union are some type of federal territory, which I heard the argument, and I don't agree with it at all. There's no evidence of it. The terminology that's being used is being commingled with different definitions from different subjects. Can't do that. You can't commingle definitions from different subjects on a thing that you're researching. You automatically violated one of the primary rules as being a researcher. So the next case, of course, is Down versus Bidwell. But most of it was already said, right? In the other case. It has here, though, the 14th Amendment provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And this court naturally held in the slaughterhouse cases that the United States included the district and the territory. So if you guys go read the slaughterhouse cases and see specifically what is the context that the term is being used. Like for right now, right? This is 14th Amendment citizenship, right? The criteria for the statute that they were fighting against is the criteria for the definition for the slaughterhouse cases. But they quote the slaughterhouse here. It says, it had been said by eminent judges a citizen, except as he was a citizen of one of the states composing the Union. Those, therefore, who have been born and resided always in the District of Columbia or in the territories, though within the United States, were not citizens. Whether this proposition was sound or not have never been judicially decided. It's never been brought up. It's new. But this first sentence right here, right? You know by the reading of the Constitution and the Declaration of Independence that we have bounded ourselves together through states so that we may travel, be respected, and do business in each state without being scrutinized as completely as another foreigner. Okay? For you to be seen as the same standard as a citizen from another state, like you're from California, you're going to New York, for you to be held at the same standard and for the same laws to apply to you, right? Equality, right? You're considered a citizen of the several states of the Union. That's protected by the federal government. That is not a state protection that you get. A citizen of the several states of the Union is the first national, like, citizenship, protected solely by the federal government. If your rights are being violated in another state that you're not a citizen from, the federal government steps in to protect those rights. But the criteria, the establishment of a United States citizen has already existed, just not completely defined as the 14th Amendment did, especially on how to acquire it, aside from naturalization. Here they're stating it that just by being born in a state, right, that you were a citizen of one of the states composing the Union. That is what a United States citizen is. A citizen of one of the states composing the Union. That right there is a citizen of the several states of the Union. That right there is a United States citizen. Those, therefore, who have been born and resided always in the District of Columbia or in the territories, though within the United States, were not citizens. Whether this proposition was sound or not had never been judicially decided. Well, we know for sure, being born in the territories, at least in 1945, and then again in Belmonte, the answer is no. You're not a citizen if you're born for sure over there in them territories. Except if it's given by statute. Not by the 14th Amendment, it's by statute. So like the District of Columbia with U.S. citizenship, I guarantee you that's by statute. Especially since this judge right here is stating it. They're not citizens. Not as a birthright from the 14th Amendment or the 4th. Or the 4th Article 4. And he said the question was put to rest by the amendment, and the distinction between citizenship of the United States and citizenship of the state was clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of the state, but an important element is necessary to convert the former, meaning from a United States citizen into a state citizen. He must reside within the state to make him a citizen of it. But it is only necessary for he should be born or naturalized in the United States to be citizen of the Union. Do you think that this term right here, the United States, means the territories? When they're talking about to be a citizen of the Union? A citizen of the Union is not a state citizen. They go into the 15th Amendment. And this court, I didn't say it, this court case dealt with articles from Puerto Rico under the Uniformity Clause. That's what this was. So Hooven was about the Philippines on some committee, on some Uniformity Clause. Valmonte was immigration issue on a woman using the 14th Amendment because she was born in a territory, the Philippines, while it was still a territory before it became independent. I'm trying to show you guys the line. Where am I finding? I'm not finding nothing about it's a corporation. In regards to citizenship, I need you guys to understand this. In regards to citizenship, in regards to the 14th Amendment, in regards to Article 4, there is nothing that construes in any way that it's a corporation in that context. It's for sure, as I've seen, it's not the territories. Since after 1871, the District of Columbia created a corporation to deal with those territories, then, where's the tie-in? Even more so, since the 14th Amendment was passed before the corporation was created. How could someone be a citizen of that corporation? Even if you guys watched my other videos, right, on citizenship, you will understand that citizenship is a common law principle. A corporation cannot be a citizen. There's court cases for this. Both under Article 4 and under the 14th Amendment, a corporation cannot be a citizen. They are persons. So my next case, right? So this right here gives you the definition of how they construed what the 13th Amendment, the 14th Amendment and the Uniformity Clauses. They broke down how it only applies to the states because that's if and when it was, written. The next case, I think I'm going to read the whole thing, good portion. This will deal with the citizenship aspect. So all these dealt with definitions to the United States and that the territories were not included in the United States. Neither is the District of Columbia. All right, we're talking about 14th Amendment, third term, the United States. The District of Columbia is not included in that definition. So this right here is 3 years before the 14th Amendment. 3 years before the Civil Rights Act of 66. So 5 years before the 14th Amendment was even passed. I'm reading this one because the citizenship aspect is better, and they quote Dred Scott versus Sanford, which is 56. So you're talking about 10 and 12 years before the Civil Rights Act of the 14th Amendment. There's another case that I would like to bring up, but that's from 1830. So for those who want to continue their research and go up the line, right? But for the purposes that I'm doing here, is not required, right? So let me start with this one. This dealt with a European, a white guy, who emigrated over here, right? Wanted to join the militia. And he conformed to the state's definition of for how to join the militia, right? The state's method or whatever, that what do you got to be, a white male citizen, and you have to reside within the state for like a month or something, okay? This was an argument that just because he was given citizenship for the purposes of the militia under state laws, that doesn't make him a citizen of the United States. And yeah, they're calling it citizen of the United States before the 14th Amendment. So the only thing that they're calling him is a citizen of the several states. So let me read. We have already decided in the application of Greiner for a writ of habeas corpus that the Act of Congress of 1862 authorizing the President to make the necessary rules and regulations for drafting the militia in cases where the laws of the states had not made sufficient provision for that purpose was valid. The only question left then is to be determined in this case is whether a resident of this state, so this is Wisconsin, a resident of this state who was a native of a foreign country, but who had declared his intention to become a citizen of the United States and taken out his first papers in accordance with the laws of Congress. So whatever that means here, this is the legal stuff, right? Following some procedure, and has exercised the right of voting under the Constitution and laws of this state, all of which are true of the petitioner, was liable to be drafted, question mark. So that's the question. The decision of this question depends upon the meaning of several acts of Congress and the laws of this state. In regard to the militia, for it has been the policy of the general government, where they're talking about the United States government, in all of its legislation hitherto, that means up to now, upon this subject, to trust so much to the action of the states that it becomes necessary to consider the entire system of legislation, both state and federal, to have a correct understanding of the laws of either. So they're basically saying that the federal government never dealt with this question. Right? It's not until the 14th Amendment and all that stuff and citizenship with whatever, that's when they really start dealing with legislation on it. So they're looking to consider the entire system, both state and federal. The Act of Congress providing for the organization of the militia, approved May of 1792, designated as the persons to be enrolled at every free, able-bodied white male citizen of the respective states. Now, we know if it's all about well, for sure, terminology. Okay, who could he be talking about here? I believe for sure he's talking about, right, citizens from each state. I think he's talking about state citizens here, right? Providing for the militia, it's citizens of the state. Resident therein, especially because he's saying resident therein. So why not just call them, whatever the term would have been. What would have been the term back then? It's not citizen of the several states, because that's federal. That's in the Constitution. That's not what the states describe their own citizens, aside from state citizens, right? Prior to 1858, the law of this state provided that every free, able-bodied white male person who has resided within this state 1 month and is between the ages of 18 and 45 shall be enrolled in the militia. Now, they don't use the word citizen here. They use the word person and resided. Section 5, Chapter 31, 1858. But Section 1 of Chapter 87 of the General Law, so this is the general government, of 1858, which is found as part of this chapter just referred to, designated as those who should be liable to military duty, all able-bodied white male citizens. I would like to know what this symbol means. The ampersand with the letter C and the ampersand with the letter O. I haven't searched it yet after I'm reading this as many times as I read it, but the Act of Congress of 1862, before referred to, provided that in all cases the enrollment should include all able-bodied male citizens. It thus appears that in the laws both of this state and the United States now in force, the word citizen is used as descriptive of the persons liable to enrollment in the militia. See, this is my thing right here. Okay. Up here, they used, in the state definition, they didn't use the word citizen. They used person and resided. Okay. Intention, if it domicile is is not a thing of statute, right? It's a thing of statute that a statute recognizes, right? So establishing your intent to be in one place, right? That does something in law, right? And in the states, that becomes citizenship of that state when you make your primary residence your domicile. So the only thing I could think of, because since he just gave both definitions, right? One said person and resided, and the other one said able-bodied white citizens. And then for him to say right below it, it thus appears that in both laws, right, this state and federal, now in force, the word citizen is used as descriptive as persons liable to enrollment in the militia. That means that they're taking person who has resided as citizen. That's how I would break that down. Because why else would he make that statement as both, for laws both in state and the United States? The decision must therefore depend upon the meaning of that word, citizen. Right? So their goal here is to break down the word. The commissioner decided that it meant only those who were full citizens of the United States. But before that conclusion can be adopted. So who do you think the commissioner is talking about? Because there's no doubt with the Constitution, there's a term, a citizen of the several states of the Union, and then you have state citizenship, which they didn't call them expressly citizens of the United States. Because they called them by their individual term, right? Texan, Californian, and whatever else. But before the conclusion can be adopted, it will be necessary to inquire whether the word has any other well-recognized meaning, not necessarily including the full rights of citizenship of the United States. So again, citizenship of the United States 5 years before the 14th Amendment, they're going to be quoting the shit out of a court case 10 years before that, and the Dred Scott case quotes the shit out of a court case from 1830. In the end, the question has to be asked, okay, well, if it was before and after, well, what rights, privileges, and immunities did those people have in comparison to today? And you're going to find that they have the same ones. Except now it's been written and categorized instead of like in court cases. Because that's where you found it at. You found what the rights are of citizens of the several states of the Union under Article 4 by court cases when one of the protections, like when your rights are being infringed in another state, you call on the federal government to enforce your rights. Full rights of citizenship of the United States. And if so, then to determine in which sense, so if there's other ones, in what sense it was used in these laws. So what are the laws? Of course, it's the militia. So we're going to be looking, so they're not looking at the 14th Amendment. They're looking at what citizen mean when they're writing up the militia laws. When the state did they only mean citizen or anyone within their borders who showed that they want to stay? That it has such another meaning must be admitted. Under our complex system of government, there may be a citizen of a state who is not a citizen of the United States in the full sense of the term. This result would seem to follow unavoidably from the nature of the two systems, each state being sovereign, except as to the matters referred to the general government, may, as meaning the Constitution, may, as an undoubted result of that sovereignty, confer such rights of citizenship as it pleases, so far as it relates to itself only, meaning the state could bestow citizenship on whoever they want, but they cannot bestow citizenship on the national scale. But the power having been delegated to Congress to pass uniform naturalization laws, and it being exclusive in its character, no state can confer such rights of citizenship upon an alien who has not complied with the laws of Congress, so as to make him a citizen of the United States and entitled to the rights and privileges guaranteed to citizens by the federal Constitution. Now, who are the citizens? The rights and privileges. Who are the citizens who have their rights and privileges guaranteed by the federal Constitution? There's only one. Citizen of the several states of the Union, Article 4. And for sure, at this time on this writing, because the 14th Amendment did not exist yet. This doctrine has been recently very clearly stated by the Supreme Court of the United States in the Dred Scott case, in which the question was whether a Negro could be a citizen of a state within the meaning of the Constitution of the United States, so as to be entitled to sue in the federal courts. That court said, in discussing this question, we must not confound the rights of citizenship which a state may confer within its own limits, and the rights of citizenship as a member of the Union. It does not by any means follow, because he has all the rights and privileges of a state, that he must be a citizen of the United States. He may have all the rights and privileges of a citizen of a state, and yet not be entitled to the rights and privileges of a citizen of any other state. So look at how they stated this. He yet not be entitled to the rights and privileges of a citizen in any other state. You notice he didn't call him a citizen of the United States or a citizen of the several states of the Union. He stated exactly what it is. When you leave your state, right? Because the state you're a citizen from, because you're not a citizen from Indiana if you're from California. The federal government, the rights and privileges, the federal government protects to make sure you're seen as an equal footing in the other state. with their citizens. That's what that citizenship is. Call it a citizen of the United States, citizen of the several states of the Union. I don't know how else to state that. What it does take is that you need to be a state citizen for those privileges to trigger. You have to be a state citizen to trigger the criteria of Congress, right? That's within the Constitution for you to be entitled to those rights and privileges, because that's where it comes from. Especially since this is a naturalization type case. There's a foreigner who has been in the state and did all what he needs to do within the state, but he wasn't born there. For previous to the adoption of the Constitution of the United States, every state had the undoubted right to confirm on whoever it pleased the character of a citizen and to endow him with all its rights. But this character, of course, was confined to the boundaries of the state and gave him no rights or privileges in other states beyond those secured to him by the laws of nations and the comity of states. Nor have the several states surrendered the power of conferring these rights and privileges by adopting the Constitution of the United States, which is true. They gave up naturalization, right, for the United States. Power for Congress to do. Each state may still confer upon them an alien or anyone it thinks proper, or upon any class or description of persons, yet he would not be a citizen in the sense, and this is the context, in the sense in which the word is used in the Constitution of the United States. Now, as much as people are, are strung up on certain terms and words, on how these are not capitalized, and they're not saying Constitution for the United States and stuff like that, or United States of America, and I don't know what to tell you, man. This is 1863. I can't be strung up on the terminology as is, because I know that there has to be substance behind the word that gives it context for what the meaning is. The you know what I'm saying? Like the nature of the word, of the term. Nor entitled, so it goes, the word of the Constitution of the United States, nor entitled to sue as such in one of its courts, nor the privileges and immunities of a citizen in the other states. See, that's the thing right there. Privileges and immunities of a citizen of the several states of the Union is described right here. Nor the privileges and immunities of a citizen in the other states. Right? Because it's the privileges and immunities that you receive on an equal footing as those citizens in those other states. The rights which he would acquire would be restricted to the state which gave them. The Constitution has conferred on Congress the right to establish an uniform rule of naturalization, and this right is evidently exclusive and has always been held by this court to be so. Consequently, no state, since the adoption of the Constitution, can, by naturalizing an alien, invest with the rights and privileges secured to a citizen of a state under the federal government. Right? They're telling you, you can't invest him with the rights and privileges that's secured to a citizen of a state under the federal government. Although so far as the state alone was concerned, he would undoubtedly be entitled to the rights of a citizen and clothed with all the rights and immunities with which the Constitution and laws of the state attach to that character. The power of a state to confer a right of citizenship so far as it alone is concerned, and which does not amount to a citizenship of the United States, would not be more plainly stated than it is in the above extract. It is true, however, that further on in the opinion, so he's still talking about Dred Scott, page 422, the court says, so too a person may be entitled to vote by the law of a state who is not a citizen, even of the state itself, and in some of the states of the Union, foreigners not naturalized are allowed to vote. And the state may give the right to free Negroes or mulattoes, but that does not make them citizens of the state, and still less of the United States. Which you should understand that those things are franchises, voting of the state that you're in. Like, it's not dependent on citizenship. It's a good sign that you're a citizen, but citizenship is not reliant on it. And they have a right to give it in their statutes to whoever the fuck they want. And you see that now, the argument now on TV. So what this guy is saying in 1863, you see it before your face right now with the immigrant issue. But the thing, what they're saying is that they don't have the power to state who on the national level receives the benefit, the privilege, the benefit, the protections of a citizen of the several states of the Union. That's what this case is all about. That the states don't have the right to say that. Even though the 14th Amendment says it for the states. So, yeah. Which was after. You know what? That's what I think what is unconstitutional about the 14th Amendment. It's that they are telling the states who their citizens are. Like, this whole thing was about the states dictating who their citizens are because they are sovereign and have every right to. Right? But at the same time, this case is specifically stating that, okay, well, you're fucking sovereign. Well, you gave us in the Constitution the power to do this. So you, since you gave it up, left it to us. So you can't do it. The people who benefit from being a citizen of the several states of the Union, as outlined in Article 4. But then the 14th Amendment turned around and said, the fucking federal government said, well, now we're dictating who the fuck the citizens are in your state. No doubt they can make them citizens of the United States, but to dictate to a state that they're U.S. citizens, that they're citizens of that state too. It's supposed to be the option. It's supposed to be the option of the person who's traveling to whatever state he wishes to go domicile in, and that it's applicable in that state. Like, of course, we don't have race and all that stuff in the constitutions and all that stuff no more. So, like, back then, you can't go to a state that says white only, because the courts weren't upholding it. It wasn't until after the 14th Amendment Reconstruction that now is, they can't discriminate against that. But what I'm saying, though, is you, as the person who's to go domicile, you choose where to go, what laws are going to protect your property and rights and so forth at the local level. That as long as whatever the Constitution, it abides by that, it accepts that it accepts you, right? Let's just say, still, what is here said does not detract at all from the broad doctrine stated in the former extract. It means no more than this, that the state may confer the right to vote without necessarily making those on whom it is conferred citizens of the state even. This may possibly be true but the power of the state being conceded to confer the rights of citizenship within itself upon whomsoever it pleases. The question whether it has done so or not is a mere question of intention, to be determined by the proper construction of its own constitution and laws, and one also which the supreme tribunal of each state is to determine for itself. This being so, although it may be possible for the state to confer the right of voting on certain persons without making them citizens, yet I should think it would require very strong evidence of a contrary intention to overcome the inference of an intention to create a citizenship when the right of suffrage is conferred. They just saying they're not together. The remarks of Justice Curtis in his dissenting opinion in Dred Scott states the true effect which ought to be given to the existence of this right. He says, "But further, though, as I shall presently more fully state, I do not think the enjoyment of the elective franchise essential to citizenship." So he's talking about voting. "There can be no doubt it is one of the chiefest attributes of citizenship under the American Constitution, and the just and constitutional possession of this right is decisive evidence of citizenship. The provisions made by the Constitution by a Constitution on this subject must therefore be looked at as bearing directly upon the question what persons are citizens under that Constitution. Indeed, it is often used in the general sense as meaning only a permanent resident in the state constitutions he's talking about here, who had not declared their intentions and was entitled to no political rights under the laws of the state. Was a citizen within the meaning of the attachment laws of that state against absconding citizens." It is all right. That is one of the definitions given by Webster. In Field versus Anderson, it was held that a resident alien who had not declared his intentions, which is pivotal, was entitled to no political rights under the laws of the state and was still a citizen within the meaning of the attachment laws of the state against absconding citizens. I would think that's a statute. That's not a constitutional thing. You know, a statute can do that. But it's like he's not, because he hasn't done what's required by the Constitution, right? He declared his intentions. But because of the residency aspect, they're calling him a citizen for a statute. That means he's not for sure a citizen in the political sense. He's just a citizen as a term, as a name for resident in a statute. Yet it is true that in a political sense, the word citizen implies the possession of political rights. But the rights of voting and holding office are always given as the most complete and perfect attributes of citizenship. Thus, Webster gives the following definition. In the United States, a person native or naturalized who has the privilege of exercising the elective franchise or the qualifications which enable him to vote for rulers and to purchase and hold real estate. Rulers, huh? Bouvier's dictionary is as follows. One who, under the Constitution and laws of the United States, has the right to vote for representatives in Congress and other public officers, and who is qualified to fill offices in the gift of the people. At least that definition, that's more federal, right? Vote for representatives in Congress, meaning voting on the federal side. Bearing in mind that the inquiry relates only to such rights of citizenship as the state could confer, with respect to itself alone, how should it be determined upon our Constitution? With respect to the class of persons to which the petitioner is, in this case, belongs, the answer must be that there is no room for doubt that it was the intention to confer upon such persons, as far as it was possible for the state to do so, the full rights of state citizenship. In the first place, those persons had an equal voice with any other citizens in establishing the Constitution itself. By Section 9, Article 14, they were authorized to vote upon the adoption or rejection. By the Article of Suffrage, they are made qualified electors and are eligible to all offices except as governor, lieutenant governor, or judges. And they're talking about the citizens who they give full rights, meaning the ones who are not born there, right? Because under the Constitution, both state and federal, like for president, the Constitution is president and stuff, right? And Supreme Court justices, you have to be a natural born citizen. And here it's the same thing. You cannot be a governor, lieutenant governor, or a judge. At least I would think the Supreme Court, right? If it fits with the same as federal, unless you're a natural born citizen of that state. Here, they're referencing the article, because I went to go look. They're referencing the article that applies to those coming to the state to become one of their citizens, not those born. By the article on suffrage, they are made qualified electors and are eligible to all offices except as governor, lieutenant governor, or judges. If the granting of these rights and the right to participate in establishing the framework of the government, of an equal voice in choosing all officers under it, and the right to hold offices with a very few exceptions, does not indicate an intention to create them citizens of the state, it is difficult to imagine from what such an intention could be inferred. He's basically laughing. This distinction between citizenship of a state and of the United States is also very clearly implied in several provisions, both of the Constitution and laws of the state. So they're talking about Wisconsin. There, wherever the full right of citizenship of the United States is intended, it is so expressed, as in respect to the office of governor, lieutenant governor, or judge, it is provided that no person shall be eligible who is not a citizen of the United States. So in the Constitution, at least back then for Wisconsin, who are they talking about? Citizen of the United States. Right? Who are they talking about? They have to define it within their paperwork if it references anything federal. They have to describe this. If we take it as a citizen of the several, as a state citizen, as a citizen from one of the other states, right? Because that's ultimately what it means. But is it different than a state citizen in this sentence? No, it can't be just here talking about the state citizen stuff aspect. This form of expression never would have been used if it had been supposed that no person could be a citizen of the state without also being a citizen of the United States. In that case, the word citizen alone would have been used. An instance of this kind is found in the Bill of Rights, Section 15, which provides that no distinction shall ever be made by law between resident aliens and citizens in reference to the possession, enjoyment, and descent of property. Now it seems very clear that the words resident aliens, as used here, were not intended to include those who had declared their intentions to become citizens. Because that's the difference. One has an intention to domicile and the other one doesn't. and thereby become entitled under the Constitution to all the rights of citizenship before referred to. The framers would hardly have assumed that any distinction would have been made against them in respect to rights of property. But this provision was intended for the benefit of those who were resident aliens simply, and all who were entitled to political rights were included by the word citizens, which meant only citizens of this state. So also the second section of the article on suffrage, which provided that no person convicted of treason or felony shall be qualified to vote at any election unless restored to civil rights, clearly assumes that an elector under the Constitution may be guilty of treason against the state, but he could not be guilty of treason unless a citizen. And if this class of persons are not citizens, they might levy war against this state and adhere to its enemies, though perhaps filling at the same time some of its highest offices, and yet not be punishable for treason, a position in which it cannot be assumed that any government would intentionally place itself. It is also worthy to remark that although the state cannot make such persons full citizens of the United States, yet by making them electors of the state, it thereby gives them an equal voice with any other citizen. And that's the thing. That's it right there. By becoming electors of your state, that is what qualifies you back then as a citizen of the several states of the Union. Look how they say this, that although the state cannot make such persons full citizens of the United States, yet by making them electors of the state, it thereby gives them an equal voice with any other citizen in choosing senators and representatives in Congress, and also in choosing the president and vice president of the United States. For by the Constitution of the United States, representatives are chosen by the qualified electors of the most numerous branch of state legislators. Senators are chosen by the legislature, the presidential electors in such manner as the state legislature may direct. Notwithstanding, therefore, the Constitution conferred upon Congress the power of providing uniform naturalization laws. And notwithstanding, it must be admitted that an alien cannot become a full citizen of the United States except by complying by these laws. It must also be admitted that the state may, by conferring upon them the right of suffrage, enable them to have an equal voice with any other citizen in the government of the United States itself. And although they may not be full citizens, they may well be said in the general sense to be citizens even of the United States. I mean, man, this court case goes deep. There's a little bit more. I'm going to continue, though. Indeed, it was held in a memorable instances, fresh in the memory of all, that a foreigner who had declared his intention under the laws of Congress in the state of New York, whose constitution and laws did not confer on him any political rights or make him a citizen of that state, although not a full citizen of the United States, was still a domiciled citizen invested with a national character as such, and entitled to the protection of our government abroad. Let's read that again. Fresh in the memory of all, that a foreigner who had declared his intentions under the laws of Congress in the state of New York, whose constitution and laws did not confer on him any political rights or make him a citizen of that state, although not a full citizen of the United States. So here, he's showing an intent to naturalize, right, under the laws of Congress. And he's in New York. And they're stating the addition that in New York ain't giving him he's not getting citizenship in New York. And then the statement is here is, although not a full citizen of the United States. They're saying here, citizenship in New York encompasses the phrase citizen of the United States. Was still a domiciled citizen invested with the national character. Right? Because a full citizenship receives full protections, both state and federal. You're not a full citizen of the United States unless you're receiving both. And Congress awarded a medal to the gallant commander Ignahim, who promptly extended that protection to Tyre, Hungarian exile, who had declared his intention to become a citizen of the United States. The following extract from a letter of the Secretary Marcy, it's funny, Secretary Marcy, and Marcy is in capital letters, in the correspondence which followed is not inappropriate to the present discussion. He says, the right to protect persons having a domicile, though not native-born or naturalized citizens, rest on the firm foundation of justice, and the claim to be protected is earned by considerations which the protecting power is not at liberty to disregard. Such domiciled citizen pays the same price for his protection as native-born or naturalized citizens pay for theirs. He is under the bonds of allegiance to the country of his residence, and if he breaks them, incurs the same penalties. He owes the same obedience to the civil laws and must discharge the duties they impose on him. His property is in the same way and to the same extent liable to contribute to the support of the government. In war, he shares equally with them in the calamities which may befall the country. And he's talking about a resident, right? Someone who's not a citizen. Well, that's a national for sure, right? What he's describing here is a national. But he's describing this in such a way that he complied with Congress for naturalization, but New York didn't bestow those same citizenship rights on them. Right? The Constitution didn't honor whatever it is about him. They didn't honor. Services may be required for his defense. His life may be periled and sacrificed in maintaining its rights and vindicating its honor. In nearly all respects, his and their condition as to the duties and burdens of government are undistinguishable. If this is true in respect to relation between the government of the United States and a foreigner who has declared his intention to become a citizen, in a state which does not, for that reason, confer on him any political rights, it is much more true in a case where a state does confer upon such person the rights. Let's read that, because this also deals with like slavery. If this is true in respect to relation between the government of the United States and a foreigner who has declared his intention to become a citizen, in a state which does not for that reason, confer on him any political rights. So for that reason is what? Because his intention to become a United States citizen? For that reason, confer on him any political rights. It is much more true in a case where a state does confer upon a person the rights of citizenship and the qualifications of an elector, thereby making him also an elector of the United States. and entitled to a voice in choosing its highest officers. Where the state does confer upon such person the rights of citizenship and qualifications of an elector. Right? All this right here is what makes, thereby making him an elector of the United States and entitled to in a voice of the highest office. And upon the question of state citizenship between the state and such person, so far as it is possible for the state to create state citizenship, there is no room for doubt. If then the liability of this petitioner to be drafted depended upon the meaning of the word citizen in our state law, I should have no hesitation in saying that he was liable. In this act, the word citizen only is used, but where the legislator intends full citizens of the United States, they say so. Thus, the law concerning jurors, it is provided that none shall be drawn who are not citizens of the United States. A good reason for this discrimination is found in the fact that jurors are drawn by lot, while persons who have declared their intentions are made electors and allowed to hold office. Yet it might perhaps be safely assumed that no person not competent would be elected to office. But many foreigners who come here are not only unacquainted with our laws and modes of proceeding, but ignorant also of our language, and jurors be drawn by lot. If all were liable to be drawn as soon as they had declared their intentions, many might be drawn who were wholly unable to discharge the duties. Hence this discrimination in the law on that subject, but no such reasons exist why these persons should not share the burdens of the common defense. Therefore, the militia law drops the language which is used when a full citizenship of the United States is intended, and provides that all able-bodied citizens shall be liable to military duty. So they're making it not dependent on citizenship. They're removing that. And that's based on the property laws, protection of property laws of someone who is not, right? A citizen of that state. The case up here, the further thing I was reading up here. The word person in the old law would have included aliens who had not declared their intentions at all. It was to exclude them from the change was made, and it was not at all warrant the conclusion that the legislature designed to exclude all who were not full citizens of the United States. On the contrary, by omitting the language with which the intention is always expressed, it appears clearly that they had no such purpose, and I think the word citizen was used in the acts of Congress in the same sense. The original act of 1792 has already shown, provided that the enrollment of all able-bodied white male citizens of the respective states. This language expressly refers to citizenship of the states. So that's how he's getting in, right? The state acknowledged him to be in the militia. But the differences in words, they were trying to say that this word citizen applied to U.S. citizen, that you needed full citizenship to join the militia. But the wording that they use, respective states, right, refers to citizenship of the states. And although the same language might sometimes be construed to mean only such a state citizenship as brought the party within the full meaning of all the constitutional provisions of the United States. Yet the very nature of the subject matter of this law seems to me fully to exclude any such intention. It was a question merely as to what persons should be liable to share the burdens of the common defense, and as between the state and all persons, who by its constitution and laws were made citizens of it. There can be no doubt that all such persons ought to share the burdens equally, and there is no ground for supposing that Congress intended by the words citizens of the respective states to exclude any who were citizens to all intents and purposes as between the state and them. So for them, the citizen in these clauses applied to citizens of the states. But at least they broke it down, both of them. This conclusion is strengthened by the word white in that law. The Supreme Court of the United States in the Dred Scott case says the word white was used in this law to exclude African race, and the word citizen to exclude unnaturalized foreigners. That makes sense, right? I mean, you would think citizen is specific, and it means everyone. It doesn't include everyone else, but then they restricted it more by using white. Now, whether the use of the word white as qualifying citizen for the purpose of excluding the African race would indicate that in the opinion of Congress, the African race could not be citizens at all, may perhaps be very questionable. Its use for such a purpose would, on the ordinary rules of construing language, seem to imply that those who used it understood that if it was not so qualified, the African race might be included by the word citizens. If that race could not be citizens at all, they, as well as naturalized foreigners, would have been included simply by the word citizens. But assuming that as that court decided that the African race could not be citizens within the full meaning of the word, as used by the Constitution of the United States, yet that they might be citizens of the states, in that sense in which each state would confer citizenship within itself, and that all this was understood by Congress, which enacted this law, then the use of the word white for the purpose of excluding African race could only be accounted for upon the theory that the word citizen was not used in its fullest constitutional sense, but as referring to the state citizenship before alluded to. It could only have been the meaning of the word citizen which justified or required the use of the word white. And with this meaning, the word citizen would include persons in this state of the class to which the petitioner belongs, the state citizenship. But even if there was doubt as to the correctness of this construction of the law in 1792, there can be none as to its correctness when applied to the Act of 1862, under which this draft took place. In the first place, the Act referred to the matter of the laws of the several states, where they were insufficient. So if this state had a law sufficiently providing a mode of drafting, the petitioner being able to enrollment as citizen under our law would have been included. but it is unreasonable to suppose that Congress intended to allow such persons to be drafted where the state laws were sufficient, yet to exclude them by the word citizen in cases where the president had to make rules and regulations for drafting. In this law, also the word white is omitted, evidently for the purpose of removing the prohibition against the African race. For the 12th section expressly authorizes the president to receive them into the military or naval service. This shows the word citizen is still used with reference merely to state citizenship. This conclusion is straightened also by the provisions of another act of the same date. Chapter 200, Laws of Congress, Volume 12, page 594. The 21st section enacts that any alien who should volunteer in the service of the United States and be afterwards honorably discharged might become a citizen of the United States without any previous declaration of intention and without being required to prove a previous residence of more than 1 year. Can it be possible that Congress, anxious to fill armies of the Union, and while passing one act to induce entire aliens who has never declared their intentions at all to enlist, intended in another act passed at the same time to exclude from liability to military duty by the use of the word citizen? Those who have declared their intentions, who have become citizens of the state, and take part of the election of the highest officers of the United States, they never could have had such intention. The word citizen referred to state citizenship and was not intended to exclude those of the class whom the petitioner belongs. The constitutions of several other states have extended to these persons rights of citizenship similar to those given by this state. They have enjoyed the privileges and protections of citizens. They have filled the offices, taken part in the enactment of state laws, and had an equal voice with others in the elections of the officers and enactment of laws of the United States. They have found free homes among us under our government established upon the principles of civil and religious liberty and equality of rights. Among them, they have shared our prosperity. When we are prosperous and happy, and by every single principle of justice and every sentiment of honor, they ought to share the burdens in this honor of calamity and trial. And it is to be hoped that instead of shrinking them from this high duty, they may be no less willing to bear their share of the burdens of war, than prompt to claim privilege and preferment in times of peace. The order of the commissioner must be reversed. So what is it that we learned? Right? No doubt, just in this year, referencing Dred Scott 10 years before, they called them citizens of the United States. Power in naturalization was vested in Congress. They determined who are the ones who benefited from them. But because of the way the Constitution is written, those born or have the intention through naturalization to domicile and be a full citizen in the state and to partake in those, or have the eligibility to partake in the system itself, right? That's what makes you a citizen of the several states of the Union. At least a good part of it. There has to be a qualification for that. Because regardless of the difference of the wording, in the end, Congress is saying citizens. They want the full strength of it. Well, okay, well, it was defined here that persons that domicile in a state with a full intention of citizenship and to participate automatically become part of the citizen that, for sure, at least on the militia clause, which in the end is a state citizen. But no doubt, like this should be more than enough to understand that, one, it's a birthright. All they did was create the mode by birth, something that was already established by being born in a state. Those are natural born citizens that could get that. These people, through naturalization, have to do other things for them to acquire that. Because the state couldn't give it to them by statute. It had to be embodied in the constitutions. Birth is one of them. Literally, the requirement, just birth, being born in one of the states. I don't know how else to stress that. And we could go further. Dred Scott, 1856. Or Engales. What's the case? F. No. Control F. Why is it? Engales? No. Or Ig. IGNAL. I forgot how to spell it. It's the 1830 case. Maybe I'll find it really fast. I don't know how else to put it. Like, it's not citizenship that has screwed you. I don't know how else to put it. It's persons that has screwed you. Citizenship has nothing to do with corporations and territories. Not for the Article 4 and not for the 14th Amendment. You can't keep saying that the definition of the United States only means one thing when there's court cases saying it means three things. And it means different things in different subjects. Yes, it means a corporation under Title 28. So what is Title 28? So what is Title 28? Does it have anything to do with the 14th Amendment? Oh, look at this. The court system. Procedures. Come on, man. That definition is only within this title or that chapter. Title 15, same thing. Yes, a United States citizen is a business. Yeah, specifically for Title 15. It doesn't mean nothing for the 14th Amendment. It's what they called something. Vilmonte flat out told you right here, like flat out, like the Constitution is to its people. Citizenship under the 14th Amendment, however, is not extended to any person. It's extended to persons born in any place, subject to the United States jurisdiction, but is limited to persons born or naturalized in the states of the Union. Like, I'm not understanding. And then they go on to tell you, yeah, the term United States has a broader meaning. Okay, in what context does it have a broader meaning? With foreign sovereignties. I don't know how else, like, I challenge anyone who made it this far in the video to provide me proof that we're corporations of a corporation, vice versa, or one or the other. When for sure there's court cases that flat out says that corporations cannot be citizens. And it violates the principles of common law for a citizen to be a citizen of a corporation. Not only that, the Act of 1871 and every other amendment for that corporation called the District of Columbia, they don't have powers of naturalization. That stayed with Congress. They don't have powers to determine who are their citizens. That stayed with Congress. Like, what the fuck? Have a debate, a real serious debate. Show proof, show paperwork, show something. Not he said, she said, or here's a story, or here's a definition. From a subject that don't apply to the context, to the thing you're researching at that moment. Sorry for the rant, but hopefully you guys enjoyed this. But take down these cases. Hooven versus Allison. Read them for yourself. Vilmonte versus Immigration and Naturalization Services. The Lima versus Bidwell, but of course the most famous one, and it's famous because of the dissent of Judge Harlan at the end. But the Lima versus Bidwell, Downs versus Bidwell, great cases. This is the PDF version of the last case that I just read. So this one, the European trying to join the militia. All I'm saying, man, stop being cognitive dissidents. You're being showed evidence in front of you that needs to be contradicted for the theory that has been passed down for so long about citizenship, about the terminology of citizen of the United States, U.S. citizen, the United States, right? Well, this needs to be contradicted right here. I don't know how else to put it. This needs to be contradicted. And with that, I'll end it. Hour and 43 minutes, longer than I wanted. But hopefully something was learned. All I'm saying is if you believe something that you cannot prove, right? Aside from religion, you're doing a disservice to yourself in the legal realm as a researcher. That only takes you so far. That theory will disgustingly conflict with other aspects of law if and when you go and choose to learn other aspects of law. Because that's what happened to me, and that's what made me question that whole theory. No doubt, the United States is a corporation, but in what context? And prove to me without a shadow of a doubt that it is in the context of citizenship, the 14th Amendment or Article 4. Come on, man. Have a good one, guys.